Welcome everyone, welcome here in the Blauwe Zaal. We have this large setup today. Welcome to this program, this lecture program by Studium Generale of the Eindhoven University of Technology. In the past weeks we discussed several topics like sex and drugs and like music as a treatment in healthcare. But today we're going to discuss another very serious and very current topic, international humanitarian law. Every day in the media, we see the terrible consequences of war and conflict, the ongoing war between Israel and Hamas in Gaza, the war in Ukraine, and we all know the images of people suffering from the brutal attacks. And the question is, to what extent international humanitarian law is ignored in these situations? Because even in war, rules apply. Rules that are set by the international community itself. And the question is the international community, the United Nations, for example, the European Union, European Commission, able to hold countries accountable? Well, to answer these questions, we've invited Marieke de Hoon. She's an associate professor at the University of Amsterdam, and she's also a legal expert in international criminal law and human rights. Over the next 60 minutes, she will give a general introduction to the principles of international humanitarian law and discuss examples and issues from recent conflicts. And of course, there will also be time for Q&A during the hour. So, please give her a warm welcome, Marieke de Hoon.
Good afternoon, everyone. A full house, and thank you so much for having me here. It is it's a pleasure to be here and to talk to so many people here, mostly men. In my profession, law, I'm a law professor and criminology. There's mostly women, so this is a very pleasant deviation from that. And at the same time, it's always great to talk about these issues, and I'm sure that many of you come here heavy-heartedly because we're seeing so much harm to people, all sides. Everyone hurting in Gaza, Israel, but also in so many other conflicts in the world. And that is what we're going to talk about. I'm going to give a legal perspective, to talk to how we as lawyers, international humanitarian law lawyers, and international criminal lawyers look at these conflicts. So you understand why we see certain things in a certain way, and therefore this conversation is not going to be too political, because that's a different discipline, and that's also sometimes what I do. I got my PhD on the law and politics of the crime of aggression, and I'll come back to what the crime of aggression is. It's the jus ad bellum, the law to go to war, but today we talk about the jus in bello, the law in war. And with Syria, ISIL, Ukraine, Myanmar, the Rohingya, South Sudan, Yemen, Nagorno-Karabakh, Afghanistan, Somalia, so many others. We have so many wars around the world, unsparing of civilian life. And thanks to technology, we're at the University of Technology, but thanks to technology, and particularly smartphones, the whole world is also knowing and watching what is going on. And one may feel estranged, quite estranged, by talking about law and war. I know I am, and this is my profession, so I can't imagine what everyone else is thinking. Yet, there is law that applies, even though too often, even though one too often doesn't get too happy about how fighting sides actually comply with it. Today, I'll discuss what that law entails and also how it applies in the Gaza war. And we're also going to talk about, in the end, what this law then really is about. And I already talked to some people and here in the front rows, and they were like, what do you mean with law and war? It means law is non-existent, or law is just what the winning party feels like. How many people in the room are kind of on that perspective, coming in here saying, you know, what is this about? I'm just putting my hand here. Hands up if you're kind of like, BS. Law is whatever one wants it to be. I can see that. How many people think more optimistically, thinking, no, law is important, it has a role to play? Oh, that's a big majority. Okay, let's talk more about what that then is, because what role is that to play? So we'll get there in the end, or not, depending on your views, and then we'll look at whether some of this has changed minds or not. As a first distinction, I already mentioned it, there's a distinction between the jus ad bellum and the jus in bello, a law to go to war. So when we talk about Ukraine and Russia, for instance, we talk about the invasion, the special military operation by Russia. That is typically a topic for the jus ad bellum. Whether that was lawful, whether that's a humanitarian intervention to prevent the genocide that was going on, supposedly, in Ukraine, or self-defense because NATO forces were trying to attack Russia. Those are questions of the jus ad bellum. And today we're talking about international humanitarian law, the jus in bello. Notwithstanding whether the force was lawful or not, what are the rules that apply to the fighting sides, to the combatants there? And so we call the jus in bello international humanitarian law. What is international humanitarian law? Well, the ICRC, the International Committee of the Red Cross, and we actually have a volunteer for the ICRC here sitting. We just talked. She teaches, what is your name? Petra teaches as a volunteer for the ICRC international humanitarian law at secondary schools, right? Are there other people that volunteer for the ICRC or do similar things? That know things about ICRC, IHL, and so forth? ICL experts? Nope. All right. The International Committee of the Red Cross is an important organization that safeguards and educates the world also about international humanitarian law. And it says it's a set of rules that seeks for humanitarian reasons to limit the effects of armed conflict. It protects persons who are not or no longer directly or actively participating in hostilities and imposes limits on the means and methods of warfare. It has on its website that it's established in 1863, and it operates worldwide, helping people affected by conflict and armed conflict, and promoting the laws that protect victims of war. It's an independent and it's a neutral organization. You can recognize them by the Red Cross or the Red Crescent that they carry, and the idea is that international humanitarian law always allows them to operate neutrally and to assist victims of war. It was founded by Henri Dunant, and he was a businessman, was traveling around, and at some point he was at Solferino, and there was a battle going on in the 19th century, and he saw the horrors, all the people, the wounded coming into the village, and he helped, and he thought, this is ridiculous, why are we doing this? The wars are putting so much harm to innocent civilians, and already wounded soldiers, we must do something. And so he founded with other people the ICRC, and that was also really a start of international humanitarian law. It's part of international law, meaning that it is law that states agree to, and it raises obligations upon states, but it also raises obligations, puts obligations on those that are fighting, the combatants. They are not allowed to put unnecessary harm to civilians. They need to adhere to the principle of distinction, always looking at what am I doing? Is that attacking a military target, or is it causing civilian harm? And sometimes civilian harm, civilian infrastructure, civilian deaths have to occur, collateral damage. That may be fine, but it cannot be the primary target, and it really needs to be assessed in accordance with the military advantage. And whether then it's necessary, can there be a different way to do this? Then they probably have to, depending what is reasonable. This is law. You're always weighing. This is why also Lady Justice has these scales. So it needs to be necessary in accordance with necessity and proportionate. So even though there's a big military advantage, and it can be the only way to do it, if there's a disproportionate amount of civilian destruction, civilian deaths, then you cannot do that. It's an unlawful attack. It would violate international humanitarian law. International humanitarian law, it only applies in armed conflict. So we call this in law lex specialis. You'll see we lawyers like our Latin. It means that in normal situations, some law applies, but in a very special situation like armed conflict, then the lex specialis for armed conflicts, international humanitarian law applies. IHL is mostly found in the Geneva Conventions. There's 4 of them, and then there's some additional protocols, but there are also some other agreements and sources. But you hear a lot talking about, there's a violation of the Geneva Conventions. It's 1949, and most of the obligations and prohibitions to attack civilians, to protect wounded, soldiers that are wounded, for instance, cannot be killed, prisoner of war status, and all those kinds of rules, they are embedded in the Geneva Conventions. And so the core of it is protections of those who are not or no longer taking part in fighting, and restrictions in the means of warfare, naming weapons, certain weapons like cluster bombs in residential areas, or chemical weapons. Chemical weapons are always prohibited, and certain methods that would unnecessarily target civilians prohibited. If you want to know more, then you can ask Petra, or go to the ICRC website, which is really a great resource. We all use it as well, people that actually do this for a living. They are a whole body of experts in IHL, constantly updating and putting in very accessible language all these different challenges that are relevant on the battle floor. Now, what can we do against IHL violations? Because it's great to know what the law is, but we see a lot of wars that may not really be complying with IHL. So what can we then do? There are 2 courts in The Hague that sort of could perhaps do something, but they're always mixed. Who knows the difference between these? Who knows what these buildings are? Hands up. A few. Okay, let's do the other way around. Who has no idea what these buildings are? Or the distinction? All right. You're in, not only here, but you're also regularly in the majority. Even journalists that are specializing in this, they're always writing about Ukraine and Gaza and all that. They still mix them up. That's why it's important to distinguish them. One is, and these are the insides of those same courts, so the left is the Peace Palace, and the International Court of Justice, ICJ, is in there. And to the right is the International Criminal Court, the ICC. Here's the insides. And the left one, the ICJ, International Court of Justice, is about the law between states. States are there on horizontal level. There are obligations, they have treaties, and both of them need to comply with that. And if they don't, they can sue each other, theoretically, before the International Court of Justice. I say theoretically because both states actually need to consent to a case at the ICJ. How often do you think both states will accept the jurisdiction of the ICJ? Not so often. So that's why we don't have a lot of cases, and we don't have a lot of case law jurisprudence coming out of the International Court of Justice. There are a few exceptions. The most important one, and the reasons why we see some cases, also on Russia, Ukraine, as well as now on Gaza at the International Court of Justice, is because there is a little bit of a sideway, in Dutch we'd say geitenpaadje, and it's called compromissory clause. Some treaties, in a treaty, there can be an article, a provision, that says, for ratifying states, so states that consent to a certain treaty, both states now hereby consent with ratifying that treaty, that if in the future there's going to be a conflict, a dispute on the application or interpretation of that specific treaty, they now hereby consent to then being able that one state can go to the International Court of Justice. Now, there is no IHL treaty that has that kind of compromissory clause, and a lot of other treaties also not on aggression. So when there are cases on wars at the ICJ, it's always through other treaties that do have that provision. So for instance, now with the Gaza situation, that is also why South Africa is using the Genocide Convention to have that proceedings, because the Genocide Convention in Article 9 has that clause. And so what then South Africa is doing is, of course, trying to squeeze that case through the Genocide Convention. This is separate from the argument whether actually indeed maybe there is a genocide going on, but it's also really trying to squeeze the whole war through that lens, because that is the way to get the ICJ to rule on it. And also with Russia-Ukraine, you've also seen this. Obviously, there was no genocide going on being committed by Ukraine against Ukrainians, but because Russia was saying that the Ukrainians were committing genocide, Ukraine said, oh, okay, now we have a dispute over genocide. And so Russia said, this is nonsense, because it was nonsense. But Ukraine still, got a little bit in that system, and now the court is like, mostly sort of done with that case. But it is a way to get the court engaged, and therefore to give them a podium. You see them all 15 or 17, depending on the case, giving out a ruling, saying something about the conflict that otherwise they cannot. So, states, horizontal, International Court of Justice. International criminal justice is not horizontal in the sense of equal parties. International Criminal Court is criminal law. It's vertical. It's an individual in the dock. It's an individual, not a state. Individual people that have to stand before the judge and defend their case. A prosecutor has brought the case to the court and said, this, we believe that there are crimes being committed, and that person is then being prosecuted. So the big difference is states and individuals. But these courts, they need evidence. And so in the past, it's always been very difficult, and in the present still, to actually have cases, particularly criminal law cases, against people, because it is so hard to find evidence for crimes being committed in ongoing armed conflicts. You cannot go there and do your forensic investigations, crime scene investigations. It's too dangerous. And if a state is not consenting, for instance in Syria, you're also violating sovereignty. And so in recent years, this has been a huge revolution in the evidence collection and analysis of for international criminal law. Because especially with Syria and the Arab Spring, at the same time, technology allowing smartphones use very widely, widely and wildly maybe, many people started live documenting, videotaping with their smartphones, putting it on social media. And then also that have open source investigators, OSINT, maybe you know this, you're very technical minded here, of course, doing all sorts of really amazing work with the information they find from these people uploading videos, photos, audio, but also connecting that to weather data, satellite data, all sorts of GPS masts, connecting then the location, making geolocation reports with satellite information, indeed checking that a building, that a video, lots of videos say that was destroyed, indeed was not there the day before the video, and was there before the day of the video, and wasn't there after. All sorts of technology doing very interesting things now that is also entering the courtrooms. For instance, in the MH17 case, this is a video that the Openbaar Ministerie, the Public Prosecution Office, has made and showed in court, connecting a lot of dots with people having videos, showing that to the courts, and at the same time showing all sorts of information of where that video was shot, where the telephones were radiating on which masts. Then Gaza. Extremely difficult and painful situation for everyone involved. Israeli people were attacked. This, of course, is a long conflict, and Israeli people were attacked heavily on 7 October 2023, and then responded. The law of it is very complicated, mostly also because of the long history and the difficulties for international law to know whether this is an occupation and what occupation actually means under international law. This is a reason, and I'm showing these pictures, by the way, as a lot of what IHL is about is that you cannot bomb in residential areas, but what do you do? And that's, of course, what it looks like, not the first picture, but what do you do when those that are attacking you are shielding among the people in residential areas? The big challenge and dilemma of this war for Israel. There's a long history, and I just said the difficulty is also about what legal framework applies, what was happening, what is that history, and how to understand it, different views. And so the General Assembly of the United Nations has asked the International Court of Justice, that one on the left, or I should say for you this, the Peace Palace, to give an advisory opinion on what the occupation, what that means under international law, that situation for the Palestinian territories, and what that means for third parties, for other parties, in relation to the human rights and the right to self-determination of the Palestinian people. It is requested in December 2022, so before the current events. And there were oral hearings last week or 2 weeks ago, a few weeks ago, and somewhere in 2024, maybe an outcome will come, which hopefully will give some guidance to both parties to find a way to close this continuing decades, generations long now, fight, war, conflict. But we don't have that yet. What we also have in the running is ICC investigations. So already prior to the 7 October attacks by Hamas. The ICC, the state of Palestine, which is accepted as a state party to the ICC, which thereby also made a statement that it was not recognizing Palestine beyond the necessity of the ICC. So pretty much what they say is, yes, we accept the state of Palestine as part of the International Criminal Court because the purpose is to spread our wings, to spread our jurisdiction. So if an entity comes to us and says, we want to be part of it, that is for the advancement of human rights norms what we want. So they accepted it, and at the same time saying, we are not making any claims thereby or recognition of the state of Palestine. It's a bit how international politics and law tend to work. So the state of Palestine is part of the ICC and therefore referred to the situation in the Palestinian territories to the International Criminal Court already in 2015. And they have jurisdiction from 2014 even. I won't bore you with all the legal details, but what I'm trying to say is there was already a preliminary examination, and in 2021 that was upgraded to an investigation. And that means that we're already looking at specific cases. So this is all about the situation before 2023. Then the terrible brutalities by Hamas occurred, and the International Criminal Court has immediately announced that it has jurisdiction over those as well, because for every member state, including the state of Palestine, any of its nationals that would commit international crimes, so war crimes, crimes against humanity, thereby falls under the jurisdiction. So that investigation has expanded. But that also applies for the responses by Israel. And so the International Criminal Court, Karim Khan, has said that is looking into this carefully. So what we're going to focus on is the military actions by Israel on Gaza since. That is mostly also because the Hamas brutalities aren't very complicated, in the sense that they are horrible. They violate every international law. It's it's very clear-cut, and there's really no debate among international law scholars about the criminal nature of those acts. What is more complicated is the side that is responding to that, Israel, and to what extent you can respond to that, given all the dilemmas that are also outlined. How do you fight someone or a group that is fighting among civilians? So that is what the rest of this lecture is about. There's 4 examples that I want to address of how international humanitarian applies in this situation that has raised concern among experts and among UN panels. And so I want to discuss them to show what the legal framework is for those examples. And that has to do with humanitarian aid and blocking thereof, or allegedly blocking thereof, the attacks, hospitals, and the requirement to take precautionary measures. Humanitarian aid and the blockades of trucks mostly, but think also about water, electricity, fuel, and so forth. On the OSCE/OCHA website, you can always find everyday updated information on Gaza. And this is yesterday's report. It's very small letters, and I'm summarizing by saying what we all know is horrible humanitarian disaster going on. The obligation of fighting parties, and therefore also Israel, a siege as such is not prohibited, but it's an obligation to allow free passage of relief supplies. So Rule 55 of like customary norms of international humanitarian law reads that the parties to the conflict must allow and facilitate rapid and unimpeded passage of humanitarian relief for civilians in need, which is impartial in character and conducted without any adverse distinction, subject to their right of control. Now, this seems clear, but it's, of course, a challenge, because trucks come in and you have a right to check, but not to intentionally halt and hamper. And that is very difficult to assess. But it is the easiest to assess, given all the other complexities that I'll discuss when we talk about attacks. It includes drinking water, food, electricity, fuel, as I said. And what is very important is that it's irrelevant whether it is in response to Hamas crimes. So there is no justification for intentionally blocking humanitarian aid as a means to fight the war. So it's also not true, sometimes, that you hear that it is about a full blockade, as if only a full blockade would be a violation of IHL, because sometimes you hear the arguments, yes, but some trucks got through, or those trucks got through, therefore there's no violation. That is not true. It really is about that rapid and unimpeded passage, that free passage of relief. And it's important, this norm, because most deaths of starvation occur to young children and the elderly, pregnant and lactating mothers. They are not the ones that are fighting a war. And survivors also can face long health impairments, lifelong impairments. Now, first of all, it can be a violation of humanitarian aid if that is blockaded as a means of warfare. But if it's done intentionally as a weapon of war, it may also amount to a war crime, but also a crime against humanity and a method of genocide. And here it's important to go back to the different legal frameworks. So international humanitarian law is the law that applies in conflict, but not every violation of IHL is also a crime. Not all violation of IHL is also a war crime. It's gross violations of international humanitarian law, and mostly with intent. This is where it becomes so hard to prove. It is something that Karim Khan, the chief prosecutor of the International Criminal Court, has immediately addressed, though, pointed out that preventing aid may be a crime under ICC jurisdiction, and he did that immediately on 29 October, because this is something that they have now jurisdiction over, they have huge concern with. It really targets those that, first, of course, the ones that Israel is not trying to target. I think, but that's my personal view, I would imagine that Hamas fighters would get to the aid sooner than some of the children. It's something that the ICC, that I would expect that if a case would emerge, then that is something, I think, by the way, to make clear, if there would be a case, I would expect there also to be a case against Hamas leaders because of their violations and clear crimes. But if the ICC would have evidence to go to cases, and if they also then have cases against Israeli leaders, I would expect that it's a high likelihood that the humanitarian aid would be a first case. And the reason for that being all the things I just said. It is, even though also hard to prove intent, but much easier than the ones I'm going to address in a while. But it targets innocent people particularly. And humanitarian aid blockades, we've now seen increasingly for the last decades. In Nagorno-Karabakh, we've seen this, Sudan, South Sudan, Yemen, Syria, everywhere. We're watching this, we're seeing this, and the ICC could not do anything. So this might be a case that they would be interested in really investigating to see. Let's see. So humanitarian aid is one thing. The other thing that we're seeing, of course, and that questions arise constantly, is attacks by Israel, whether or not they violate international humanitarian law. Now, let me be clear at first, is that it is lawful to attack militarily. It is also lawful that people will die in that, if done in accordance with the requirements of IHL. Now, it's more difficult to assess that because those requirements depend on classified information, on assessing the requirements. Because it's about military advantage, how much military advantage did on the basis of the intelligence that the commander at that point had was expected, and what did the intelligence say about the expected civilian destruction. That is something that's very hard right now from here in the Netherlands or wherever, from a distance to actually know. It's actually impossible to know. So that's also why you see my colleagues and I always being very careful for assessing of an attack. Because it's something that may look like or may amount to, but we cannot here determine without that intelligence that it is a war crime. So what needs to be assessed is what I just said. Like, you have to then, if you want to attack, and there's a military advantage, you may attack, but if there is civilian harm to be expected, it becomes a weighing. It can still be allowed to attack when civilian infrastructure, civilians can be killed, but then it becomes a weighing with necessity, proportionality, and the obligation to take precautionary measures. Now, a question also very often is, well, what do you do? Hamas fights with Palestinians using them as human shields. It's impossible to not kill them. Well, IHL doesn't say if you try everything and still you would kill a lot of civilians and the balance is off, then you're not to blame, you can't help it. IHL says if you cannot do it without disproportionate civilian harm, you're just not allowed to do it, period. It's not up to IHL to say how you then can do it. IHL says it means you just cannot. And while it's difficult to assess then per attack separately, in its whole, many experts report that many of the attacks appear in violation of IHL and may amount to war crimes. And what we're talking about particularly then is the attacks on residential areas, and this has a lot to do with the principle of distinction. Everyone, every combatant is obliged to apply the principle of distinction, meaning that they need to assess they need to distinguish between military target and civilians. For residential areas, that's extremely hard. And so bombing a residential area is prima facie, at first sight, Latin again, at first sight, very red flaggy. This also counts for attacking fleeing people. So warning that an attack is pending, saying you should flee there, but then also attacking those flight routes. Very hard to justify with how much of the military advantage that actually would have brought. But it can also be a mistake, and this is also why we need to be careful. But in court, then the defendant does need to explain that it is a mistake. You cannot just say, you cannot know, and therefore you cannot blame me. So the burden of proof shifts when you are saying that it was a mistake. People trying to get humanitarian aid that we saw last week, hospitals, and also perfidy. And I'm going to address these now. What you hear a lot in this conflict is because Hamas uses hospitals, they lose their protective status. Hospitals are protected. And indeed, they lose their status when that special status, when they are being used by military, for instance, as a military command post. But that does not mean that that's the end of it. And that is something you hear quite a bit in the rhetoric, as if losing that status means I can now attack. When it loses that special additional status, it still falls under all the regular rules of what is, weighing, what is that military advantage, weighing that against the necessity. Are there different means to get that military advantage? And weighing that with proportionality. And the proportionality is extremely hard when you're talking about hospitals with people there. You also need to give all sorts of precautionary measures to try and have already a contingency plan in place. What is going to happen with the people, the sick, the children, where are they going to move, and all sorts of other important precautionary measures. But what also weighs in then in that proportionality assessment is when already quite a few of the hospitals are struck, and when even more people than normal need the hospitals, it weighs much heavier in the equation whether that's a proportionate target. And so attacking hospitals, even though it may lose that special protective status when used by fighters, by combatants, it still is really rarely acceptable that that would actually be a lawful target. Even though that immediately makes that for fighters in asymmetrical warfare like Hamas, that means it's a very tempting position to take. Perfidy might have happened here. Who knows what perfidy is? If someone knows, you can scream.
Operation under a false flag?
Yes. So perfidy, indeed, operation under a false flag. Like if you are pretending to fall under a protection, like a white flag, or using like the costume of a doctor, using the ICRC emblem, then the other party should be respecting that because you're saying, I am of a protective status. And so if you abuse that, that is weighed very heavily under IHL and also may amount to war crime. Recently, I think it was 31 January, we saw this video of allegedly Israeli that used a doctor's costume to enter hospital and then make an assassination. Another point where international humanitarian lawyers would immediately think, there is a lot to explain then from the other side. And of course, having to know whether the information is correct, which is something that every war nowadays really requires careful assessment of. Then finally, the fourth, precautionary measures. Yesterday, a precautionary measure, I already said, right? Even if that assessment of military advantage versus civilian harm, and there are no other ways that is done better with, and the civilian harm doesn't seem to be too heavy in comparison to that military advantage, you still need to take precautionary measures. You still have to warn. You still have to try and decrease the civilian harm even further. And yesterday, there was a very good blog by Larry Lewis on just security. So who's interested in this, I think it's an interesting read, a good read. And I'll briefly summarize it. And this is about that some Israeli leaders and commentators claim that Israel's taking unprecedented care for civilians, even upholding a gold standard by giving warnings, sending texts, and also doing roof knocking. And that is sort of small, sort of little, not explosive little bombs to warn, like falling on the roof, so you know, something's coming, and we need to get out of this. So Larry Lewis is someone that helped define the field of civilian harm mitigation, and he says, no, this is not a gold standard, and he goes quite a bit further. He says the gold standard, this civilian harm mitigation, is about, first, the process. It is about a learning process and a comprehensive process. You need to learn. If something doesn't work under current circumstances, you need to adapt. You need to be better in warning. You need to be better in taking preventive measures. And if the measures, therefore, clearly don't, and another thing also very important, you can warn, but if there is nowhere to go, then that is not in compliance with IHL. So the warnings to say we're going to bomb these residential areas go south, but then not being able to go anywhere that is safe is also one of these things that don't look good from an IHL perspective. And then he also says, let's look at the data, and you're like technology people, you like numbers, I don't, we lawyers don't. It is very difficult to look at numbers, and that's also what Lewis says, because all of the information is, you need to be very critical on it. And so the data where he says what we do is have average number of civilians killed or harmed per 100 attacks. And it's not like it's difficult, but he was one of the lead in a scrutiny in a report of the urban operations in Raqqa in Syria. And there, 1.7 out of 100 was deemed not good, let alone gold standard. Here he says it's difficult with the data because Palestinian and Israel use different data, but even if you use the Israeli numbers, which he doesn't find credible, he says you come to 54 compared to 100. And this is someone that really, this is a US world leader in doing this civilian harm mitigation. And he comes out now, yesterday, with this post. And I found that really, because all of us understand, I wouldn't claim all of us, but I think most people, definitely in my field, we understand how complex war is. We understand how very complex and difficult it is to fight a war against people that use human shields and attack you all the time. And that you have that obligation not to harm civilians. How then do you fight this war? That is extremely difficult. But to see those numbers, to see the numbers and to see the pictures, is also something where what we say is there's a reason why we have IHL. There's a reason why we have international law. We created it. It's not coming from somewhere foreign. We created it as a global world society. Humans created this because over and over we're killing each other, and over we're seeing how that is just spiraling further out of control. And that is what Henri Dunant wanted to stop. That is what he said. Killing or creating additional grievance to civilians only creates more and new injustices. And that is what IHL is trying to stop. Now, what can law do to end with? We talked about some accountabilities. So the ICC is investigating. It hasn't announced anything. Prosecutors don't tend to announce anything until they do, usually with an arrest warrant, as we've seen in the Russia-Ukraine situation, where for the child abductions, again, children. So that's also why I think the humanitarian aid might be a priority, because protecting the children, they are so clearly innocent. So that might be a priority. We've also seen in tribunal case law, for instance, the Yugoslavia tribunal, that there is little understanding from judges, criminal judges, on high civilian casualties. We just briefly touched on the ICJ case, so the International Court of Justice of South Africa versus Israel. It's not about IHL, because they have no jurisdiction over that, but through the genocide, and that there's an advisory opinion coming up, which I think is the most important. Hopefully, it will be a very fair and honest assessment of how Israel and the Palestinian authorities need to understand that their relations with each other and their human rights obligations, and that the world, all sides, can finally find a way to abide by that, to make that parties abide by that, whatever it's going to be. I don't know what that outcome is going to be, but I really wish for the people in Israel and the Palestinian authorities that there's a way to move beyond this terror. There's also more case law in domestic systems, such as the Netherlands. We had this F-35 case, where some NGOs sued the state for its supporting Israel with F-35 supplies. In appeal, the court agreed and said that the Netherlands could not do that export. It will go to the Supreme Court. And I think yesterday, the day before, or last week, very recently in Denmark, a similar case is now being done. There's also fact-finding missions, human rights reporting, and so forth, for hopefully documentation, so that in the future, because law can bring you a little bit of accountability perhaps, but also there's going to be a very strong need on all sorts of other transitional justice processes if these people over there, these poor people that are all victims of this, must find a way to live together again, which is, I think, what we all hope. So, it doesn't bring peace, that is for sure, all that talk about law, because there's been some judgments, there's been some UN experts, panels, lots of lawyers that have said, this violates law. So far, that hasn't really affected much on the ground, it seems. But maybe that is not the full picture. Because I do think that, and I don't know, but I can imagine that it is fighting parties that are in a dispute. They live in their own reality. They are hurt, and they're fighting for a reason. They're not voluntarily fighting. They fight because they must, or at least that's what they feel. And so I do think that it is important that the rest of the world tries to help solve that situation in a constructive way, and we've seen a lot of not so constructive ways. So who knows, maybe some of these cases can help push the diplomacy in constructive ways. But that's politics. You know, law can maybe provide some help there, but it's the states that need to will this, that need to do this, that it then depends on. And does it bring justice? It doesn't bring dead people back. It doesn't bring lost ones back. It doesn't rebuild Gaza. It doesn't get the hostages back. It doesn't, solve all the harm already done. So what is the point? And this is where we begun, right? I have my moments too, or very often, and I think a lot of people in the room few people, actually, majority said. So that's also why I want to end with some positives, because actually I do think there is important points to law, because we can look at law as something that can't do much, and that is true. But we can also look at how decades ago, only a few decades ago, we had none of this. And there was all that fighting, and there was actually no lectures on IHL. There was no attention to it. There were no pressure, there were no cases. And so at least you can also see it's something. So it's not much, but not nothing. It provides us a shared language to look at politicized conflict with rules that are applicable to all sides. So in that sense, it neutralizes. I really do not have, I'm not pro or against the other, and I think a lot of lawyers have that. We look at rules, and so that language hopefully can depoliticize some. Law gives a structure to investigate, to then also to investigate what, would be violations of norms and what not. Justifications also, and to verify and analyze evidence. It gives forums where parties can argue on how the law should be interpreted. It allows norm setting, establishing norm, enforcing, saying what is right and wrong, communicating that also to the world, and very importantly, that also gives a way to acknowledge victims, to tell them that they are seen and that they are heard, which is extremely hard when the world is actually watching and not doing so much. But still, through a process, through a legal process, and I've closely followed the MH17 next of kin throughout their legal processes and sat with them and being in court and hearing the prosecution, weighing all the evidence in public, and then a court ruling on that, was also telling them, you're not crazy, you're right. And it also communicated to people in Ukraine that were saying, since 2014, that Russia was in Ukraine, saying, you were right, we were wrong for not listening to you. So that is also that sense of communication and acknowledging victims. And finally, but very importantly in our current era, legal rulings, even though they come way too late and have so little teeth, they can be very important in actual, careful fact-finding on the basis of evidence, fighting disinformation. For now, trying to influence the battlefield, trying to influence sides that are pushing conflicts in one or the other direction, but also for the future history books. Because if one thing also we've learned from science, from researching, studying centuries of conflicts, is that it's that intergenerational conflict, constantly feeling and fighting the injustices of previous generations, that is just fueling and fueling more and more spiraling of conflicts. And so what you hope is that with actual facts based on evidence, maybe future history books can do something positive for the future of communities trying to live together. Thank you. Long
Marieke,
story.
Yeah, thank you very much for sharing your knowledge and taking us through this complex material, but also ending with these positives and also hopeful notes regarding striving for peace and striving for justice. Thank you very much for giving this talk today. Marieke de Hoon.
Thank you.
Thank you all for your questions and being here, and hope to see you next time at Studium Generale. Bye-bye.